Hi, Jack Ryan here with the Law and Best Practices and the Critical Tasks in Law Enforcement Operations. This is part of an ongoing series where we talk about the high-risk critical tasks, a number of different areas, use of force, vehicle pursuits, dealing with the mentally ill, domestic violence, persons of diminished capacity, and we could go on, care, custody, control, and restraint of prisoners. But these are a little bit longer than our roll call series. And we hope to bring you both the law and best practice and keep you updated on what's happening throughout the country through this series. Thank you for joining us, and hopefully you'll find it useful for you. The case I want to talk to you about today is Armstrong versus Pinehurst, and it's a case out of the Fourth Circuit that has implications on use of force, dealing with the mentally ill, as well as TASER. The case involves Ronald Armstrong, a paranoid schizophrenic, obviously off his medication. His sister convinces him to go to a hospital in North Carolina, Pinehurst, North Carolina, the Moore Hospital. He's being examined there and being evaluated. Some of his odd behavior as he was poking holes in his leg to let the air out is one of the things that comes up in the case, and it's one of the reasons why his sister was concerned. While being examined, apparently he gets frightened and he actually flees from the hospital. Now, one of the facts that come up in the case is a doctor then signs a mental health commitment order. But one of the important pieces of that, we see this coming up in some of the cases, is the doctor checks off that he's a danger to himself, and although there is a box available to say that he's dangerous to others, that box is not checked off. When he flees from the hospital, and even before the commitment order is signed, 3 officers from the Pinehurst Police Department respond to the scene, a lieutenant, a sergeant, patrol officer, and they find Mr. Armstrong a short distance away. In fact, when the officer first spots him, he's at an intersection, the hospital driveway and the active roadway. He kind of convinces Mr. Armstrong to move off the active roadway because he's kind of walking around in that area. And obviously he doesn't want him on the active roadway. And they're standing off to the side. There is some conversation taking place for a period of time. The court also notes that in addition to the 3 officers, there's also 2 security officers from the hospital present, as well as Mr. Armstrong's sister. They're asking him to go back to the hospital, but the commitment order is not signed yet. There's a conversation taking place. And at some point, the officers get notified that the commitment order is signed. Now, one of the things that the court's going to end up taking issue with this is about 30 seconds after the commitment order is signed, there's a determination made to use the TASER on Mr. Armstrong. When the officers move in to grab Mr. Armstrong after telling him that the commitment order has been signed, he grabs a hold of a pole. It's a 4x4 pole that's holding up a sign, and he grabs a hold of the pole, and he's got his arms wrapped around it really tight, and he's clinging to that pole. It sounds like he probably had his legs wrapped around it as well, but he's clinging to that pole, and he won't let go. His sister is there begging him to just let go and go back to the hospital. There's 2 security officers there available, and there's 3 officers. As I said, one of the first things the court takes issue with, and you can see this when you read the case, is that they don't like the fact that within 30 seconds they don't try to have a conversation, but instead they decide to use the TASER. So the lieutenant orders the patrol officer to deploy the TASER. They deploy it not in the probe mode. They deploy in the drive stun mode. Now that becomes an issue as well in the case. In fact, the court cites to some TASER International material, some material from PERF that would indicate that in the drive stun mode that it's pain compliance only, and sometimes when persons are suffering from mental impairment, they don't feel the pain, so it may not work and it may actually cause a further problem. Bottom line is they deploy the TASER 5 times. Instead of having the desired effect, Mr. Armstrong actually hangs on tighter to that pole. They're unable to remove him. So at some point, the security officers join the police officers, and they're able to muscle him off the pole. They do get him on the ground. There is information in the case that there is some weight put on his back. One officer standing, one officer kneeling on Armstrong's back, and he's held down and handcuffed. The court describes that when the officers stand up to, quote, collect themselves, he's still kicking, so they actually shackle his legs as well, and then they leave him on the ground. What ends up happening is after a period of time, the sister looks and says, my God, my brother's not responsive. The officers go check him, and sure enough, now Mr. Armstrong is in dire straits. In fact, they call for immediate EMS. When they turn him over, he's blue. They immediately rush him to the hospital, and he dies a short time later. Now, in analyzing the case, the Fourth Circuit looks at a number of different factors, but they always start off, as every use of force case does, in looking at the three factors from Graham versus Connor, which is, 1, how serious is the offense? 2, what's the immediate physical threat to the officer or anyone else present? And 3, is the subject actively resisting or attempting to evade arrest by flight? I will tell you that in this case, and we see some courts doing this from time to time, we just saw the Supreme Court do this in the Kingsley case, which is actually a jail use of force case, talk about the proportionality of the force versus the need for the force. So in other words, did you use force at a high end when the need was really at the low end? So again, you know, sometimes it's good to think of that in terms of, and again, not that we want to hurt people, but in terms of a hurt scale. In other words, we have different tools. Some tools don't hurt at all, for example, officer presence and verbal commands. Some tools hurt a lot, for example, the firearm. So there's a distinction on this proportionality scale between, you know, what the degree of hurt is or harm that can be caused to the individual by the use of force. In taking the first factor, the Fourth Circuit said, hey, look, there's a distinction between when officers are making an arrest versus officers conducting a mental health commitment. An arrest is different than a mental health commitment. So seriousness of offense goes in favor of Armstrong. In fact, the court says that even if you look at potentially a resisting type of charge on Armstrong for resisting the officer's efforts to take him into custody, it would be a very minor offense. The court then turns to some other factors, and this goes to both resistance as well as physical threat. They note that Mr. Armstrong is kind of a big, heavy-set guy. He's 5'11", he's over 260 pounds, he's clinging to the pole, he's not moving. In fact, the court says he's seated and clinging to the pole. One of the things to remember, and I'll just point this out as we pass through all these facts, is that this case is on summary judgment and qualified immunity. So when the court considers the facts, they have to consider the facts in the light most favorable to the plaintiff, Miss Armstrong, or Mr. Armstrong's family, in this case, for example, his sister. So if his sister is reporting these facts, these are the facts as the court will have to accept for purposes of summary judgment. At trial, the officers may not agree with these facts. In fact, testimony may come out that's very different from these facts. When it comes to physical threat, the court noted he's sitting on the ground. He's not being assaultive. He's clinging to the pole with both arms. The court says, hey, that's not the type of conduct that poses an immediate threat. This is resistance, yes. Justifies some use of force, yes. But it doesn't justify a serious use of force, something that does potentially cause harm. And so the court says, hey, that type of threat wouldn't justify the use of the taser. The court did not distinguish, and we see some cases that do this around the country. They distinguish the taser between the drive stun mode and the probe mode. We've had a number of cases where courts have said that the drive stun mode causes localized pain only, does not cause an uncontrolled fall, does not cause complete neuromuscular disruption, and therefore is a lesser intrusive use of force. The Fourth Circuit did not distinguish between the two. In fact, the Fourth Circuit says that the use of TASER is a serious use of force. So my Fourth Circuit jurisdictions have to really stop and consider training and policy as it relates to TASER, because all TASER uses now going forward will be considered a serious use of force in Fourth Circuit jurisdictions. Hey, the court also looked at whether or not, what was this resistance? And they said, hey, look, this particular resistance, the only resistance that you had here, the only thing you really got left is flight, for example. Certainly there's no flight issue here because he's clinging to a pole and not moving. As far as resistance goes, the court says there's a huge difference between even physical resistance and immediate threat. So the court distinguishes those two things, and they say not all physical resistance will constitute an immediate physical threat. So again, this is a pretty restrictive look at what constitutes resistance as well. The court found that the TASER deployment in this case was unreasonable. The court did not get into things like what we would have maybe expected, some positional asphyxia or some mechanical asphyxia by getting on his back. Those things are not discussed in the case, but the court did look at, and I say three different items here. One, use of force is different when we're talking about arresting someone for a crime versus taking somebody in on a mental health commitment. The mission is different, and therefore the use of force is going to be different. And again, this is when we know they have this mental impairment, right? Two, there is going to be a distinction between the person who is dangerous to self versus danger to others. And the court hops on this a couple of times in the case where they say, hey, look, the bottom line is you're gonna injure somebody to prevent them from harming themselves. You're acting contrary to the very mission. The mission is to prevent harm, and then you're going to use serious force to injure them. The court says that doesn't make any sense, and I think we can agree with that. I guess what we could disagree with maybe is whether or not TASER in the drive-stun mode actually is a serious potential for serious harm. I think that's really the issue that we would probably take issue with, and I think in some of the other circuits have been recognized as a low level or a lower level use of force than even the probe mode. Second, when we're looking at physical threat, we have to look at what the subject's actually doing, right? In this case, he's clinging to a pole. He's not moving. When we look at active resistance, he doesn't have any mechanical implements that are holding him to the pole. It's just his muscle power that's holding him to the pole. The other thing, when we look at persons of diminished capacity, and we've been saying this for a long time, when we try to contain the person, in this case, there's no question he's contained. We try to communicate with the individual. There's no question that they were having a conversation before the commitment order was filed. And again, under the plaintiff's set of facts. I recognize that this is the plaintiff's set of facts. Additionally, the court says that it's 30 seconds between the time that the commitment order, the officers become aware that the commitment order is signed and the decision is made to use the TASER. In fact, they point out that there's only 6 minutes and some odd seconds, I think 16 seconds, between the signing of the commitment order and the call for EMS because Mr. Armstrong is unresponsive. So again, the officers did not take any time to try to de-escalate. And the court focuses on that. They say, hey, look, when you're dealing with somebody that you know is mentally ill, they're not an immediate threat or they're a low-level threat, then you got to take your time and try to de-escalate the force rather than escalate the force. The court noted, again, that it doesn't make sense to harm someone to prevent them from harming themselves with serious physical force. So again, we've got the use of force piece of this, both on the mental health side as well as the TASER side. We have the diminished capacity piece on this, where the court is looking when the person is a danger to themselves That's different from our ability to use force than when we're dealing with a criminal that we're trying to arrest. Bottom line, I think we take from this case is that when the person is only a threat to themselves, we take our time, we try to de-escalate, we try to have a conversation with them, we try to get sufficient backup there to take them into custody without having to cause any harm. Two, clearly if you're in the Fourth Circuit, the use of the taser on someone who is only a threat to themselves and refusing to follow the verbal orders of law enforcement, maybe even is resisting physically to some degree, is not enough to make a decision to use the taser either in the probe mode or in the drive stun mode. And I think, you know, the rest of us can use this as an example that we really want to consider if the person is only a threat to themselves, and again, not with a mechanical instrument, because I think if he were out there with a knife holding it to his throat, refusing to give up, I think that in that case, I think we would say, hey, better to control him with a taser, as we see that criticism when we shoot somebody that has the knife. You know, there's always this criticism that we should have considered taser. I think that would have changed things. But if they're a danger to themselves and they're not, you know, have some kind of mechanical means to carry that out, then I think we got to think long and hard before we use the taser based on this type of case. Probably important to mention, you know, the court cites to Ninth Circuit cases that talk about the mentally impaired person and dealing with them a little differently. They talk about a Nashville case, Champion. So our Sixth Circuit folks, you know, dealing with the mentally ill is different than dealing with the criminal from a use of force standpoint. They talk about some 10th Circuit cases. They talk about some 8th Circuit cases. So we do see a trend growing here, and so this is an important case to take a look at. Again, the critical points are that where we can elongate the time and communicate with the individual and forego using any kind of force whatsoever beyond, you know, verbal conversation, attempts to de-escalate and get the person to calm down and take them into custody without a need for force, the better off we're going to be. I want to thank you for taking the time to join us in this session of the Legal and Liability Risk Management Institute's Law and Best Practices series, where we try to keep you updated on the most recent legal developments that impact your job and your mission in law enforcement. Thank you for all you do out there, and please be safe.